Very good evening to all of you, friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So, friends, in this particular session, we shall be discussing about some of the most important legal developments that have taken place over the last couple of days. In this particular session, we are going to discuss some legal developments. Those developments which are absolutely important for each and every one of you preparing for CLAT and other law entrance examination to know. So guys, let's get started. But before we begin with today's session, BYJU'S Exam Prep brings to you a free workshop on how to maximize CLAT preparation during your holidays. Now, you will have a number of holidays. For example, Holi holidays, Dashera holidays, Durga Puja holidays, Christmas holidays. Now, how do you manage those holidays and utilize those holidays for your preparation, right? This particular session is going to be taken by Abhimanyu Sir. So hurry up and register now. This is going to happen on 26th of Feb at 7 p.m. Moving on. Let's start. Now, the President of India appoints governors. Governors are the executive head of states. Now, here we see that the President of India has appointed former Judge of the Supreme Court, Justice Abdul Nazir, as Governor of Andhra Pradesh. Now, we had also seen former judges of the Supreme Court, former Chief Justices of Supreme Court being appointed as governor. We had former Chief Justice of India, Justice P. Sathasivam, who was appointed as the governor of Kerala in 2014. But prior to that, we also had Justice Fatima Bibi. Fatima Bibi, who was appointed as the governor of Tamil Nadu way back in 1997. So, the President of India has appointed a very recent judge who was there in the bench, who decided Ayodhya dispute, who also decided the demonetization case in favor of the government. So there is a lot of criticism insofar as whether a former judge who has demitted office without a cooling period can be appointed by the government. Now, the president appoints, the government appoints is one and the same. Whether without a particular cooling period, a former judge can be appointed or not. Now, let's understand some important constitutional provisions relating to the governor. Now, Article 153 of the Indian Constitution categorically states that there shall be a governor in every state. Now, in every state, there are governors. Now, if you go to union territories, you have administrators or LG, lieutenant governor. They are called lieutenant governor, whereas they are called governors in state. The executive power of the state is vested with the governor and is exercised by him directly or through his subordinate officers according to the Constitution. That is what Article 154 says. So 153 categorically says that there will be a governor in every state. 154 says, I'm so sorry. 154 says that the executive power of the state is vested with the governor, and it is to be exercised by him directly or through his subordinates. 155 of the Indian Constitution says the governor of the state shall be appointed by the president. So, the governor of a state is appointed by the President of India. Very important. Those of you who are preparing for Maharashtra CET and all. Now, these are the kind of questions you often get in your examination. Now, let's come to Article 157. 157, you might not have to remember these articles, but just understand, a person to be eligible for appointment as governor should be a citizen of India and has completed 35 years of age. So the eligibility criteria that has been mentioned under the Indian Constitution insofar as a governor of a state is concerned is Indian citizen above 35 years of age. Okay? Let's move on. Article 161. 161 says that the governor also has power to grant pardon, reprieves, and others. Now, the President of India has the power to grant pardon, right? Similarly, the governor under 161 also has a similar power. 163, some important provisions of the Constitution relating to the governor. So you have a particular news. You should know in detail the powers of the governor. There shall be a council of ministers with the chief ministers at the head to aid and advise the governor. So whatever the governor does is on the aid and advice of the council of ministers headed by the chief minister. Similar provision is there insofar as the president is concerned. Whatever the president does is on the aid and advice of the council of ministers headed by the prime minister. Am I clear? So you see that the prime minister is the real head. The chief minister and his council of ministers is the real head. Now the governor, the president are like a monarch. Not they are elected like a monarch. They are just a kind of a rubber stamp. Okay. The governor appoints chief ministers and other ministers. This is the power of the governor. The governor appoints. Similarly, the president appoints the prime minister and the council of ministers. The governor appoints the advocate general of states. Similarly, the president also appoints the attorney general for India. Right? Very good. So we have understood the role of the governor. Now, before moving ahead, BYJU'S Exam Prep brings to you a comprehensive course for CLAT 2024. We shall be providing you with 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mock tests for CLAT and other law entrance examination, along with video solutions, monthly e-magazine on current affairs, and the entire content is based on our analysis of the previous years of CLAT question papers. So hurry up and get your CLAT 2024 comprehensive course if you are appearing for CLAT 2024. So guys, moving on. In a landmark judgment, the Supreme Court has upheld the Bar Council of India's power to conduct all India bar examination. Now, before you become a lawyer, before you can practice in a court of law, it's one of the most important criteria that you have to pass law degree. You have to have a law degree. And apart from that, since 2010 onwards, there is an All India Bar exam. Now, the All India Bar exam is a particular examination wherein every person who wants to argue in a court, who wants to become an advocate, has to and definitely has to pass this All India Bar exam. Now, this particular AIBE was challenged in a court of law. Now, let's see what the Supreme Court had to say about this. The Bar Council of India, under the chairmanship of Mr. Gopal Subramaniam, a very senior advocate of the Supreme Court, decided to conduct the All India Bar exam in the year 2010. Now, under the Bar Council of India rules, Rule 49 says that the general power of the Bar Council of India to make rules. The Bar Council of India may make rules for discharging its function under this act, and in particular, such rules may prescribe, very important, the class and category of persons entitled to be enrolled as advocates. So the Bar Council of India, under the rules, has the power to make rules insofar as prescribing a class or category of person who can be enrolled as an advocate. Now, under this very provision, in 2010, the Bar Council of India decided to conduct an All India Bar exam. Section 49 of the Act says that while dealing with the general powers of the Bar Council of India to make rules, specifically stipulates to a class or category of person entitled to be enrolled. So the Bar Council of India has the power. It has the power to stipulate certain conditions insofar as people who can be enrolled as an advocate is concerned. As advocates, this is what the Supreme Court has said, very important. As advocates, it is an aspect for which all powers have been conferred on the Bar Council of India. Thus, the provision for an examination for enrollment of advocates by the Bar Council of India can hardly be doubted. We had specified at the inception itself that quality control of entry into the bar is the need of the hour. Now, there are thousands and thousands and lakhs of students passing law, getting a law degree. But how many of them are really qualified to argue in a court of law? That is the real need of the hour. Now, to streamline the real merit, it is absolutely necessary that this kind of examination is conducted. Moving on. Furthermore, the Supreme Court has said that the objective of the legislature, okay, I think the objective of the legislature, while giving wide powers to the Bar Council of India under Section 49, which gives it in its power to make rules, read with certain other sections, which gives the power to prescribe the norms for entitlement. The norms for entitlement to be enrolled as an advocate under the rules of the Bar Council of India leads us to the conclusion that these are adequate powers with the Bar Council of India under the said Act to provide such norms and rules. That means under the various provisions of the Bar Council of India rules and the Act, the Bar Council of India has the power to conduct All India Bar exam. While conferring a greater role on the Bar Council of India would make the Bar Council of India more conscious of the importance of the role it has to perform, including ensuring that the only person who are well equipped with the tools of law passes the All India Bar exam. Further, in view of the periodic changes in the legal position and the consequent nature of the All India Bar exam being held, we would like to make this judgment prospective applicable. Now, those who have not done it, fair thought. But from now onwards, everyone, since 2010 onwards, if a student passes a law degree, to practice or to become an advocate, he has to pass the All India Bar exam. So similar bar exam is conducted by the New York bar, the Washington bar, and other places. Okay, California bar and all, right? Moving on, BYJU'S Exam Prep brings to you a free workshop on how to maximize CLAT preparation during your holidays. This is to be conducted on 26th of Feb at 7 p.m. by Abhimanyu Sir. Okay, so hurry up and register now for this free workshop. Moving on, the Kerala High Court was discussing about terrorism as an evil affecting the life and liberty of people. So people are affected because of terrorism in our country. Let's see what the Kerala High Court had to say on this regard, because this is a very important thing. Now, I am in this particular session bringing to you the excerpts of various judgments, because you are preparing for a passage-based questions for CLAT, right? In your CLAT examination, you get passage-based questions. Now, let's see. Terrorism is an evil affecting the life and liberty of people. It affects the growth of the nation in all respect. In fact, no religion propagates terrorism or hatred. But unfortunately, some factions or religious fundamentalists have distorted the views of religion for spreading message of terrorism and hatred without realizing the amount of damage it is doing to the society as well as to the country as a whole. Innocent youths, very, very important, innocent youths are getting attracted by the call of terrorist organization, falling prey to violence and anti-national activities. So this is what the Kerala High Court was trying to say about terrorism, which is nothing but an evil in our society. Young people are falling prey. Now, no religion preaches terrorism. No religion preaches hatred. No religion wants to propagate fighting or terrorism for that purpose. Now, over here in a country like India, there are a group of people who are anti-social, anti-national. They want to link a particular religion with terrorism. That is wrong. That is what the Kerala High Court had to say on this. And that's why I brought this particular judgment. Furthermore, it says that this act is destroying the tranquility in our society, the peace in our society. Unmindful of the freedom, liberty, and safety of their fellow beings and the integrity of the nation. Here, the allegation is that the appellants wanted to indulge in violent jihad following the call of ISIS, and they proceeded to perform harja for waging war against Asiatic powers like Syria, which are at peace with the government of India. Now, there are certain group of people who get influenced by ISIS. Now, they are joining the terrorist groups, whereas India has a good relation with all the countries except one or two. Now, just because some Indians are joining those terrorist groups doesn't makes a bad name for India per se. Is that clear to each and every one? Am I clear to each and every one of you? So guys, are you following today's session? If you are following, do press the like button and do subscribe to our YouTube channel. Okay. Now, moving on. Another landmark judgment. The Delimitation Commission of the Union Territory of Jammu and Kashmir has been upheld by the Supreme Court, by a constitution bench of the Supreme Court. Now, what is delimitation? Now, let me give you certain facts, okay? On 5th of August 2019, the President of India issued a particular order whereby the provisions of the Indian Constitution was made applicable to Jammu and Kashmir. Now, Jammu and Kashmir had its own constitution. It had its own constituent assembly. It had its own laws. Now, the President of India on 5th of August 2019 made a notification, an order, okay, Constitution application of Jammu and Kashmir order, whereby he said, President Ramnath Kovind said that the Constitution of India will be made applicable to Jammu and Kashmir. Fair thought. The very next day, 6th of August 2019, Article 370 was deleted. First, the Constitution of India was made applicable to the state of Jammu and Kashmir. The very next day, what happens? The President says Article 370 is removed. Wait, understand this. On 31st of October 2019, the Parliament enacted the Jammu and Kashmir Reorganization Act. Now, what is reorganization? Now, since the government decided that these in the Union Territory of Jammu and Kashmir, the former state of Jammu and Kashmir was divided into Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. Now, the Union Territory of Jammu and Kashmir will have a legislature of its own. That means people will have a right to vote and elect their chief ministers, like Puducherry, Delhi. Now, so Jammu and Kashmir Union Territory will have a legislature. Since this legislature there will be a legislature, there has to be a delimitation. Constituencies have to be chalked out. How much area will be one constituency? How much area will be some other constituency? How much other area will be some other constituencies? So dividing the entire union territory into various constituencies for election, it was required. Now, the Reorganization Act of 2019 empowered the Parliament to enact a law for creating a legislature for the Union Territory of Jammu and Kashmir, as I said. So, under the 2019 Reorganization Act, the law said that constituencies have to be chalked out for the election to the legislature of the Union Territory of Jammu and Kashmir. Let's see what the Supreme Court had to say. And this was challenged in the Supreme Court. The Supreme Court said that if you read the Indian Constitution, there is a difference between state and union territory. The Constitution makes a clear distinction between state and union territories. That can be seen from Article 1 and the first schedule. Part 5 of the Constitution deals with union. Chapter 2 of Part 5 deals with Parliament. Part 6 deals with the states. Chapter 3 of Part 6 deals with the state legislature, and Part 8 of the Constitution independently deals with union territories. So this is what the Supreme Court said. Not this. This is not very important. But over here it is very important. Now, if you read the Indian Constitution, Article 3, the Parliament has the power. The Parliament of India has the power to make new areas for new state. It can rename a new state. It can rename a new state. It can change the boundaries of the state and union territories? Now, the question was before the court, the challenge was simply this: how can the erstwhile state of Jammu and Kashmir be divided into two union territories? Does the parliament has the power to do so? Whether the parliament has the power to do so, the Supreme Court in this particular case says yes, the parliament has the power to do so, because it can change the boundaries. It can change the boundaries of state and union territories. It can also, the explanation 1 provides that clause 1 article states that a state includes union territory. Thus, explanation 1 makes it amply clear the power of the parliament. The power of the parliament under clause A of article 3 to make laws to form a new state or alter the boundaries of state, including the power to make laws to form new union territories. So there is power with the Indian Parliament. There is power with the Indian Parliament to make new union territories. It also clarifies the power is conferred on the Parliament to make laws or enact the laws to form new state, including the power to form union territories by uniting parts of any state and union territories or any other state and union territory. So the Parliament has the power to make or divide a particular state, rename it, make it a union territory or a state. Secondly, the Supreme Court said that Article 1 contains such provision for the amendment of the first schedule. And it said that as may be necessary for the purpose of giving effect to the said provision. So, in case the Parliament wants to make any kind of amendment, it can do it. Such a law must also contain such supplemental, incidental and consequential provision, including provision as to representation of Parliament and in the legislature or legislature of the state. So the Parliament has the power under the Constitution to make constituencies for a newly legislature that is being born in a union territory or in a new state. So that's the reason that now there is constitutional powers that is provided to the Parliament, and henceforth the Supreme Court upheld the Jammu and Kashmir Reorganization Act and its reorganization. Article 4 clarifies that no such law made under Article 3 shall be deemed to be an amendment. That means it is not an amendment. Now, even if there is a change, suppose a particular state is renamed, two states are joined together, or a particular state is divided, it will not be construed as an amendment under 368. And that's why you don't require ratification from 50% of the states. You do not require 50% of the states to ratify such a thing. There cannot be any doubt that when a party wants to challenge the constitutional validity of a statute, he must plead in detail the ground of which the validity of the statute is sought to be challenged. Now, the people who came to the court challenging this law did not just say that this law is bad. They did not say, why is this law bad? Now, when you are going to a court, you have to categorically state why are you challenging a particular law. You cannot tomorrow say this law is bad. You have to give reasons. Now, those reasons was missing. In absence of these specific pleadings to that effect, court cannot go into the issue of validity of statutory provision. The constitutional courts cannot interfere with the law made by the legislature unless it is specifically challenged by incorporating specific grounds of challenge in the pleadings. The reason is that there is always a presumption of constitutionality of laws. The burden is always on the person alleging constitutionality to prove it. Now, if you tomorrow say that this law is unconstitutional, you have to tell the court why or the reason why you think it is unconstitutional. Here, there was no such thing like that. The petitioners came to the court, and you cannot tomorrow come to the court and say this law is bad. Why is this law bad? Tell me the reason. No reasons was given by the petitioners, and henceforth the Supreme Court upheld. However, the Supreme Court said, we clarified that the findings rendered in this judgment are on the footing of the exercise of power made in the year 2019 under 370 of the Constitution is valid. We are aware. Now, there is also the challenge to 370. Abrogation of 370 is a challenge before another bench. And that's why the clarification from the court. We are aware that the issue of the validity of the exercise of the said powers is a subject matter of petitions pending before this court. Therefore, we have not dealt with the issue of validity. Whether 370 abrogation was valid or invalid, the Supreme Court does not say. It is pending before a constitution bench. This particular case only deals with delimitation, that is, allocation of constituencies in the Union Territory of Jammu and Kashmir. Nothing stated in this judgment shall be construed as giving our import to the exercise of power under Clause 1 and 3 of Article 370 of the Constitution. Okay? So that is what the Supreme Court said in this particular judgment. So guys, BYJU'S Exam Prep brings to you a CLAT 2024 comprehensive course wherein we shall be providing you with 300 plus hours of classes across 5 sections, 300 plus hours of recorded videos and free videos, 35 mock tests for CLAT and other law exam, monthly e-magazine for current affairs, and the content is based on our analysis of the last 5 years of CLAT question paper. So guys, do subscribe to our YouTube channel, do follow us, do like, do join our channel and download the app. By the way, I have a question for you. The question is, who gave this judgment? A division bench of 2 judges gave this landmark judgment on delimitation. I want you to answer who were the 2 judges who sat to decide on the issue of delimitation of the Union Territory of Jammu and Kashmir. Name the 2 judges in the comment section, guys. Okay? Name the 2 judges who decided on this particular issue in the comment section after the session is over. So guys, thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Bye-bye. Take care. Have a great evening ahead. Have a great weekend ahead. Bye-bye. Good night.